I was elbow-deep in seasoning my latest batch of cherry wood when Sharon Pembrook pulled up in her white Lexus SUV. The look on her face already telling me this wasn't going to be a friendly neighborhood visit. I'd lived in Riverside Estates in Springfield, Missouri for 3 years now, and in that time, I'd managed to turn my 5-acre property into a thriving small business operation drying premium hardwood for local craftsmen and furniture makers. The certified commercial kiln I'd installed 18 months ago hummed quietly in my barn, doing its job perfectly while staying well within every legal parameter imaginable. "Mr. Oakley," Sharon called out as she stepped from her vehicle, her heels clicking against my gravel driveway in that particular way that suggested she meant business. "I need to speak with you about a very serious matter." I straightened up, wiping sawdust from my hands onto my work jeans. "Morning, Sharon. What can I do for you?" She clutched a leather-bound folder against her chest like a shield, her perfectly manicured nails tapping against it rhythmically. "The HOA board has received multiple complaints about your little wood operation here. We've conducted a review, and I'm here to inform you that you're in violation of several community covenants." I felt my jaw tighten but kept my voice level. Which covenants would those be? Section 12. Subsection 4 prohibits commercial operations within residential properties, she said, her voice taking on that condescending tone I'd heard her use at community meetings. Section 18 restricts modifications to property structures without prior board approval. And Section 21 addresses noise pollution and unsightly property conditions. The thing was, I'd done my homework before installing the kiln. My name is Harrison Oakley, and before moving to Riverside Estates, I'd spent 15 years as a commercial contractor. I knew how to read regulations, permits, and legal documents better than most lawyers. The kiln I'd purchased wasn't just some hobbyist setup. It was a certified commercial-grade lumber drying system, EPA approved, with all the proper permits from the county and state of Missouri. "Sharon, I've got all my permits in order," I said calmly. "The kiln is fully certified for commercial use, and I checked with the county before installation. My property is zoned agricultural residential, which specifically allows for small-scale commercial operations related to timber and agriculture." Her expression didn't change. "Your HOA covenants supersede county zoning in matters of community standards. You have 30 days to cease all commercial operations and remove that eyesore from your property, or will be forced to take legal action. The fines start at $500 per day." She handed me an official-looking notice from her folder, turned on her heel, and walked back to her SUV without waiting for my response. I stood there, looking down at the paper in my hands, feeling that familiar mixture of anger and disbelief that comes from dealing with petty bureaucracy. That evening, I sat in my home office, surrounded by stacks of documents. My permits from the Missouri Department of Natural Resources, my business license, my EPA certification paperwork for the kiln, my county zoning approval, and the original HOA covenant documents I'd received when purchasing the property. I'd read through those covenants 3 times before buying, and nowhere did it prohibit what I was doing. The next morning, I called my real estate attorney, Marcus Chen, who'd helped me with the property purchase. "Marcus, I need you to look at something for me." We met that afternoon at a coffee shop in downtown Springfield. I spread out the HOA notice alongside my covenant documents and permits. Marcus, a sharp guy in his 40s who'd built a reputation for not suffering fools, read through everything with careful attention. "This is interesting," he said after a while. "The covenant section she's citing, Section 12, subsection 4, It does mention commercial operations, but there's specific language here that exempts agricultural and timber-related activities. Your property deed explicitly includes those agricultural rights because of the zoning classification. So they're wrong. They're either wrong or they're deliberately misinterpreting their own rules, Marcus said. And this threat of $500 per day, that's not even in their enforcement guidelines. The actual fine structure starts at $50 for first-time violations, with escalation only after repeated offenses. They're trying to intimidate you. I leaned back in my chair. What do I do? Write them a formal response. Cite the covenant exemptions, include copies of all your certifications and permits, and make it clear you understand your rights. If they push back, we'll go from there. I spent the next 2 days crafting a detailed response letter. I wasn't trying to be combative, just clear and factual. I explained that my kiln operation fell under the agricultural exemption, that it was properly certified and permitted, that it produced minimal noise thanks to its modern design, and that it was located in my barn, completely out of view from the street. I included photographs showing how the barn looked from various angles outside my property, copies of my permits, and the specific covenant language that protected my rights. I hand-delivered the letter to Sharon's house the following Monday. She answered the door in yoga pants and a designer top, her face registering surprise when she saw me standing there. "Mr. Oakley, this is highly irregular. All HOA correspondence should go through official channels." "I wanted to make sure you received this personally," I said, handing her a sealed envelope. "It's my formal response to your notice. I think you'll find everything addresses your concerns." She took the envelope like it might contain anthrax. "The board will review it at our next meeting." 2 weeks passed without a word. I continued my work, drying a beautiful batch of walnut for a furniture maker in Branson. The kiln hummed along, maintaining its precise temperature and humidity levels, turning green lumber into stable, usable wood. The technology was actually fascinating. The commercial unit I'd installed used a combination of dehumidification and heat, all controlled by computerized sensors that adjusted conditions based on the wood species and moisture content. It was far more efficient and quieter than traditional kiln methods. Then, I got the second letter. This one wasn't from Sharon, but from a law firm in Springfield, Pemberton and Associates. They represented the Riverside Estates HOA, and their letter was far more aggressive than Sharon's initial notice. They claimed my response was inadequate, that my interpretation of the covenants was incorrect, and that I now had 14 days to cease operations or face immediate legal action and daily fines of $1,000. The escalation from 500 to 1,000 told me everything I needed to know. They weren't interested in reasonable discussion. This was about power and control. I called Marcus immediately. "They've hired lawyers. Send me everything," he said. "This just got interesting." Marcus filed a preemptive action with the Greene County Circuit Court, seeking a declaratory judgment that would legally establish my right to operate the kiln. The filing included every piece of documentation we had, plus an additional brief from a Missouri zoning attorney who specialized in HOA disputes. According to Marcus, Missouri had become increasingly protective of property rights in recent years, with several court decisions limiting HOA authority when it conflicted with county zoning and state permits. The HOA responded by holding an emergency special meeting. I received notice that I could attend and present my case to the full board, which consisted of Sharon as president, 2 other members I barely knew, and a retired lawyer named Bob Hendricks, who'd always struck me as reasonable during general meetings. The meeting was held in the community center on a Thursday evening. When I arrived, I was surprised to see nearly 40 residents in attendance. Apparently, word had spread about the dispute. I recognized several people I'd sold firewood to over the years, including Tom Winters, who lived 2 streets over and bought all his smoking wood from me. Sharon called the meeting to order, going through the usual procedural formalities before getting to the main event. We're here to address the ongoing violation by Mr. Harrison Oakley regarding his unauthorized commercial operation. If I may, Bob Hendricks interrupted, I've reviewed Mr. Oakley's response letter and his supporting documents. I think we need to carefully consider the agricultural exemption language. Sharon's face tightened. The board has already reviewed his claims and found them insufficient. This is a residential community, not a lumber yard. With respect, Sharon, Bob continued, his property is zoned agricultural residential specifically because this section of Riverside Estates was developed on former farmland. Those agricultural rights transferred with the property deed. I don't think we have the authority to override state-issued permits and county zoning. The covenants are clear, Sharon insisted. Commercial operations are prohibited. Tom Winters stood up from the audience. Can I say something? Harrison's operation doesn't bother anyone. It's quiet, it's clean, and it's completely on his own property. I've been to his barn. That kiln is more high-tech than my kitchen appliances. You can barely hear it running. Another resident, a woman named Patricia Goldsmith, spoke up. I live 3 houses down from Harrison. I didn't even know he had a kiln until this controversy started. Whatever he's doing, it's not affecting anyone else. Sharon banged her gavel. This isn't a general discussion. We're here to address a covenant violation. I raised my hand. May I speak? Sharon looked like she wanted to refuse but nodded curtly. 5 minutes. I stood, keeping my tone respectful but firm. I appreciate everyone's time tonight. I want to be clear about what I do. I operate a small-scale lumber drying business. I purchase green wood from local sawmills, dry it in a certified commercial kiln, and sell it to craftsmen, furniture makers, and woodworkers throughout southwest Missouri. The kiln I use is EPA certified, commercially rated, and fully permitted by both the state and Greene County. It's enclosed in my barn, produces no visible emissions, and operates at noise levels below ordinary household appliances. I pulled out my phone and showed a video I'd prepared. This is a sound meter reading taken at the property line. 62 decibels. That's quieter than a normal conversation. The county noise ordinance allows up to 75 decibels during daytime hours. Mr. Oakley, Sharon interrupted, the issue isn't just noise. It's the principle of commercial activity in a residential area. Then let's talk about principle, I said. When I purchased this property, I did extensive due diligence. I read every word of the covenants. I verified the zoning. I obtained every required permit. I invested over $80,000 in equipment and barn modifications based on the legal right to operate this business. The agricultural exemption in Section 12, subsection 4, Paragraph C specifically states that timber processing and agricultural commerce are permitted activities on properties with agricultural zoning designation. Bob Hendricks cleared his throat. Harrison's right. I've now read that section 3 times. The language is pretty clear. Sharon's face was turning red. The intent of that exemption was for residents who might keep chickens or have a small garden stand, not industrial lumber operations. It's not industrial, I countered. It's classified as small-scale commercial, which is exactly what the zoning allows, and the covenant language doesn't distinguish based on scale. It either permits timber-related activities or it doesn't. The language says it does. The meeting deteriorated from there. Sharon refused to back down, insisting the board had the authority to interpret covenant language as they saw fit. Bob Hendricks argued that the board's interpretation powers had limits when confronted with clear legal permits and zoning rights. The third board member, a quiet woman named Linda Ferraro, seemed uncomfortable with the whole situation and mostly stayed silent. Finally, Sharon called for a board vote on whether to proceed with enforcement action against me. Bob voted no. Linda abstained. Sharon and the other board member, a guy named Keith Drummond who hadn't said a word all meeting, voted yes. With a 2-to-1 vote with one abstention, Sharon declared the motion passed. "Mr. Oakley, you have 7 days to cease all commercial operations," Sharon announced. "Failure to comply will result in daily fines and a lawsuit seeking injunctive relief." I left the meeting frustrated but not defeated. Marcus had anticipated this outcome. The next day, he filed an emergency motion for a temporary restraining order to prevent the HOA from imposing fines while our declaratory judgment action proceeded through the courts. The judge assigned to our case was Helen Morrison, a no-nonsense jurist known for her careful attention to property rights issues. The hearing for the temporary restraining order was scheduled for the following week. In the meantime, things got weird. I started noticing a black Ford Explorer parked across from my property at odd hours. One morning, I walked out to my barn and found someone had spray-painted "No Commercial Zone" across my driveway gate. I filed a police report, and Officer Jim Patterson came out to take photos and statements. "You're the guy with the HOA dispute, right?" Patterson asked. "My cousin used to live in an HOA in Texas. They tried to fine him for planting tomatoes in his front yard. These organizations can get crazy." "Someone's taking this pretty seriously," I said, looking at the spray paint. "I'll increase patrols in your area," Patterson promised, "and I'll see if we can pull any security camera footage from neighboring properties." The vandalism rattled me more than I wanted to admit. This had started as a bureaucratic dispute over permits and covenants. Now someone was destroying my property. I installed security cameras around my barn and house that afternoon, high-definition units that would capture clear footage day or night. The restraining order hearing arrived. Marcus and I sat at the plaintiff's table while the HOA's attorneys, a team of 3 from Pemberton and Associates, occupied the defense side. Sharon sat behind them, her expression triumphant, like she'd already won. Judge Morrison reviewed the filed documents before calling the hearing to order. "This is a request for a temporary restraining order to prevent the Riverside Estates HOA from imposing fines on Mr. Oakley while the underlying declaratory judgment action proceeds. Mr. Chen, present your argument." Marcus stood and delivered a clear, concise presentation. He walked the judge through my permits, the zoning classification, the covenant language, and the agricultural exemption. He showed photographs of the kiln, played the noise level video, and presented declarations from 3 of my neighbors stating they had no complaints about my operation. "Your Honor," Marcus concluded, "Mr. Oakley has done everything by the book. He obtained proper permits, followed state and county regulations, and operated within his legal rights. The HOA is attempting to impose restrictions that conflict with superior governmental authority. Missouri law is clear that HOA covenants cannot override state permits or county zoning when properly obtained. Allowing the HOA to impose fines while this matter is resolved would cause irreparable financial harm to Mr. Oakley's legitimate business operation." The HOA's lead attorney, a silver-haired man named Richard Pemberton, stood next. "Your Honor, This is a simple matter of contract enforcement. When Mr. Oakley purchased property in Riverside Estates, he agreed to abide by the community covenants. Those covenants restrict commercial operations. The HOA board has determined his activities violate those restrictions. The board has broad discretion in interpreting and enforcing its own rules. Counselor, Judge Morrison interrupted, what about the agricultural exemption language in the covenants? Pemberton barely hesitated. That exemption was intended for minor, incidental agricultural activities, not commercial enterprises. Where in the covenant language does it specify that limitation? The judge asked. The intent is clear from context, Your Honor, but the actual language doesn't contain those restrictions. Pemberton shuffled some papers. The board's interpretation reflects the community's understanding of the covenant's purpose. Judge Morrison spent several minutes reading through the covenant excerpts in her file. The courtroom was silent except for the occasional rustle of paper. Mr. Pemberton, she finally said, I'm reading Section 12, subsection 4, paragraph C. It states that properties with agricultural zoning designation may engage in agricultural commerce and timber processing activities subject to county and state regulations. Mr. Oakley's property has agricultural residential zoning, correct? Yes, Your Honor, and he has obtained all required state and county permits. That's his claim, Your Honor, but it's not just his claim, Counselor. I have copies of the permits right here, issued by the Missouri Department of Natural Resources and Greene County. They appear to be valid and current. She looked up. Why should this court allow your client to override these governmental permits based on a covenant interpretation that seems to contradict the covenant's plain language? Pemberton tried to recover. Your Honor, HOA covenants serve an important function in maintaining community standards and property values. If we allow every resident to operate whatever business they want, that's not what's happening here, Judge Morrison cut him off. We're talking about a specific exemption in the covenant language that appears to permit exactly what Mr. Oakley is doing, on property that's zoned for exactly this purpose, with proper governmental permits. I'm not seeing where the HOA has the authority to prohibit this. She made her ruling from the bench. The temporary restraining order is granted. The HOA is prohibited from imposing any fines or taking any enforcement action against Mr. Oakley regarding his lumber drying operation, pending resolution of the declaratory judgment action. We'll schedule a preliminary injunction hearing in 30 days, and I'm ordering both parties to participate in mediation before that hearing. I felt a wave of relief wash over me. It wasn't a final victory, but it was something. Sharon's face behind the defense table had gone pale. As we left the courtroom, Pemberton approached Marcus. We should talk about settlement. I'm listening, Marcus said. The HOA is willing to drop all enforcement action if Mr. Oakley agrees to certain operational restrictions. Limits on hours of operation, screening requirements for the barn, perhaps a limit on the volume of wood processed. Marcus glanced at me. I shook my head. I'm already operating within county restrictions on all those things. I'm not agreeing to additional arbitrary limits just to make Sharon happy. Think about it, Pemberton said. Litigation is expensive and time-consuming. A reasonable compromise benefits everyone. After they left, Marcus and I grabbed lunch at a diner near the courthouse. They're worried, Marcus said. That hearing didn't go well for them. Judge Morrison clearly thinks you're in the right. So why keep fighting? I asked. Pride. Stubbornness. Maybe Sharon's convinced she's protecting the community. Or maybe there's something else going on we don't know about yet. The mediation session 2 weeks later was tense and unproductive. The mediator, A retired judge named Albert Kovach tried to find common ground, but Sharon refused to budge from her position that my operation needed to cease entirely. "Let me understand this correctly," Kovach said to Sharon at one point. "Mr. Oakley has shown that his operation is legal, permitted, and doesn't violate the actual covenant language. He's proposed additional voluntary screening and to limit operations to daytime hours only, even though he's not required to do so. And you're still insisting he shut down completely." "This is a residential community," Sharon repeated. "Commercial operations don't belong here." "Madam, with respect, you keep saying that, but the legal documents don't support your position." Sharon stood up. "We're done here. The HOA will not compromise on this matter." She walked out. Bob Hendricks, who'd attended as a board observer, looked embarrassed. "I apologize for that. Some of us on the board think this has gone too far." "Why don't you remove her as president?" I asked. "She's got allies," Bob said. And honestly, most residents don't pay attention to HOA politics until something affects them directly. Sharon's been president for 6 years. She knows how to work the system. After the failed mediation, things escalated. I continued operating the kiln because Judge Morrison's order protected me, but the atmosphere in Riverside Estates grew toxic. I'd see neighbors I'd been friendly with suddenly cross the street to avoid talking to me. Someone started a Facebook group called Save Riverside Estates that posted dramatic claims about my operation destroying property values and creating fire hazards. The fire hazard claim was particularly galling because my kiln was one of the safest systems available. It was electric, temperature-controlled, with multiple safety cutoffs and a suppression system. It was actually safer than most people's gas water heaters. Then the security cameras caught something interesting. At 2 in the morning on a Wednesday, a white Lexus SUV pulled up near my property line. I watched the timestamp on the footage as Sharon Pembrook got out, walked to my mailbox, and shoved something inside before driving away. The next morning, I found a letter in my mailbox. It wasn't official HOA correspondence. It was handwritten, threatening, and claimed that if I didn't shut down my operation voluntarily, appropriate measures would be taken to protect the community. The letter wasn't signed. I immediately took the letter and the security footage to Officer Patterson. He watched the video with interest. "That's definitely intimidation," he said. "Possibly harassment, depending on how we want to charge it, but it's tricky because she's acting in her capacity as HOA president. A prosecutor might see this as a civil dispute rather than criminal." "She snuck onto my property at 2 in the morning to leave an unsigned threatening letter," I pointed out. "I hear you. Let me talk to the detective division and the prosecutor's office. At minimum, we need to document this in case things escalate further." Patterson was more prescient than he knew. 3 days later, I woke up at 6 in the morning to the smell of smoke. I ran outside to find my barn engulfed in flames. I called 911 while grabbing a garden hose, but I knew it was hopeless. The fire had too much of a head start. The Springfield Fire Department responded quickly, but by the time they got the fire under control, my barn was a total loss. The kiln, my workspace, tools, inventory, everything was destroyed. The fire marshal began an investigation immediately. While standing in my driveway, watching firefighters pour water onto smoldering ruins, I saw Sharon drive past slowly. She didn't stop, didn't wave, just looked at the destruction and kept going. Something in her expression made my blood run cold. Fire Marshal Steve Brennan spent 3 days investigating the scene. On the 4th day, he came to my house with Detective Raymond Foster from the Springfield Police Department Arson Unit. "Mr. Oakley," Brennan said, I've completed my investigation. The fire was definitely arson. Someone used an accelerant, looks like gasoline, around the barn's foundation. They wanted this to burn hot and fast. "Do you have any suspects?" I asked, though I already knew where this was going. Detective Foster pulled out a tablet. "Your security system is comprehensive. We've been reviewing the footage. At approximately 3:15 a.m., a white Lexus SUV pulled onto your property. One occupant exited, carrying what appears to be a gas can and some kind of container. The individual moved around the barn for approximately 8 minutes, then returned to the vehicle and left." He turned the tablet toward me. Even in the darkness, enhanced by the camera's night vision capability, I could clearly identify Sharon Pembrook pouring liquid around my barn's foundation. "We've already obtained a warrant for her arrest," Foster said. "Given the clear evidence and the value of the destroyed property, she's looking at charges of first-degree arson, which is a class of felony in Missouri. With the property value involved, she could face 10 to 30 years if convicted." I sat down heavily on my porch steps. I'd known Sharon was stubborn and unreasonable, but I'd never imagined she'd go this far. "Why would she do this?" "We've been looking into that," Foster said. "Apparently, Mrs. Pembrook was trying to purchase your property through a third-party LLC last year, before you bought it. She wanted to expand her own property and create a larger estate. When you bought it instead and started your lumber business, she took it personally. We've found emails between her and other board members where she explicitly states her intention to force you out of Riverside Estates by any means necessary. Those emails are going to be important for establishing premeditation," Brennan added. "This wasn't a crime of passion. She planned this." They arrested Sharon that afternoon. I watched from my living room window as Detective Foster led her out of her house in handcuffs. She was screaming something about persecution and innocent until proven guilty, but the evidence was overwhelming. The criminal case moved through the system faster than I expected. Sharon's attorneys tried to get the security footage thrown out, arguing something about privacy expectations. But Judge Morrison, who was also handling the criminal proceedings due to the connection with the civil case, rejected their motions. The video was clear, unambiguous, and properly obtained from my own security system on my own property. The HOA immediately held an emergency meeting and removed Sharon as president, installing Bob Hendricks as interim president. Bob called me personally to apologize. "Harrison, I am so sorry about all of this. If I'd known she was capable of something like this, I would have fought harder against her from the beginning." "You couldn't have known," I said. "Hell, I lived next to her for 3 years and didn't think she'd commit arson." "The board is formally withdrawing all actions against your operation," Bob continued. "We're also prepared to offer financial compensation for your losses, though I know it doesn't come close to making you whole." "I appreciate that, Bob, but my insurance should cover most of the property loss. What I want is assurance this kind of abuse won't happen to someone else." "We're completely revising the covenant enforcement procedures," Bob promised, "including mandatory legal review before any enforcement action, clearer appeal processes, and term limits for board positions." This should never have escalated this far. Sharon pled not guilty initially, but as her trial date approached and her attorneys realized how strong the evidence was, they negotiated a plea deal. She ultimately pled guilty to first-degree arson and intimidation charges. The judge sentenced her to 12 years in state prison with the possibility of parole after 8 years. At the sentencing hearing, I had the opportunity to give a victim impact statement. I looked directly at Sharon as I spoke. You tried to destroy my livelihood because you wanted my property and couldn't accept that it belonged to someone else. You abused your authority as HOA president to harass me, intimidate me, and ultimately commit a serious felony. You didn't just burn down my barn. You destroyed 3 years of work, valuable equipment, and inventory. You threatened my sense of security in my own home. Most importantly, you betrayed the trust of an entire community that elected you to protect their interests, not pursue your own petty grievances. Sharon didn't look at me. She stared at the floor, her face blank. The civil case concluded shortly after Sharon's sentencing. Judge Morrison issued a declaratory judgment explicitly confirming my right to operate the lumber drying business, finding that the HOA had acted beyond its authority and in bad faith. She also awarded me attorney's fees and costs, which came to over $50,000. With the insurance settlement and the court award, I was able to rebuild. I hired a construction crew and spent 3 months designing and building a new barn, larger and better equipped than before. The new commercial kiln I purchased was even more efficient than my previous one, with advanced monitoring systems and increased capacity. Bob Hendricks and several other board members came to visit during construction. "This is impressive," Bob said, watching the crew install the kiln's electronic control systems. "And it's barely audible. I feel foolish for not looking into this more carefully earlier." "You can't blame yourself," I said. Sharon was convincing, and most people don't understand industrial equipment. The neighborhood association has actually received several inquiries from people asking if they can hire you for custom drying projects, Bob mentioned. "Apparently, word spread about your operation, and woodworkers all over the region are interested." That turned out to be prophetic. The publicity from the case, while embarrassing and traumatic, had inadvertently marketed my business throughout Southwest Missouri. Within 6 months of reopening, I had more clients than I could handle. I hired 2 part-time employees to help manage the operation. The Riverside Estates community itself underwent significant changes. The publicity from Sharon's arrest and conviction sparked interest in HOA reform, not just in our neighborhood but throughout Springfield. The local newspaper ran a series of investigative reports on HOA abuses, and several state legislators began discussing reforms to Missouri's HOA laws. Bob Hendricks proved to be an excellent HOA president. He was transparent, reasonable, and committed to enforcing rules fairly while respecting property rights. He established quarterly town halls where residents could voice concerns and ask questions directly. The contentious, adversarial atmosphere that Sharon had created gradually dissipated. I even reconciled with neighbors who'd sided with Sharon during the dispute. Most admitted they'd simply believed what she told them without investigating themselves. Patricia Goldsmith, who'd spoken up for me at that contentious board meeting, became a good friend. Her husband was a cabine maker, and I provided him with premium dried walnut and cherry at cost. One afternoon about a year after the fire, I was in my new barn, checking the moisture content of a batch of white oak when Tom Winters stopped by. "Harrison, you got a minute?" he asked. "Sure, what's up?" "I wanted to thank you," he said. "Not just for the smoking wood you sell me, though that's great, but for standing up to Sharon. She'd been running this neighborhood like a dictator for years. Nobody had the guts to challenge her because she'd find ways to make your life miserable. What happened to you was terrible, but it exposed what she really was. The neighborhood's a better place now." "I didn't set out to be some kind of crusader," I said. "I just wanted to run my business in peace." "That's what makes it meaningful," Tom replied. "You weren't trying to prove a point. You were just defending your right to do something legal and legitimate." That resonated with people. The legal reforms that followed were substantial. Missouri passed new legislation limiting HOA enforcement authority, requiring mandatory legal review before significant fines or litigation, and establishing clear protections for property owners with proper governmental permits. The law specifically addressed the conflict between HOA covenants and superior governmental authority, codifying what Judge Morrison had ruled in my case. I testified before the state legislature during the bill's consideration, describing my experience and explaining how HOA overreach could devastate homeowners. Other people shared similar stories of HOA abuse, though thankfully, most didn't involve arson. The bill passed with bipartisan support and was signed into law by the governor. Sharon's husband divorced her while she was in prison. He moved out of Riverside Estates, and from what I heard through the neighborhood gossip network, relocated somewhere in Arkansas. Their house sat empty for several months before finally selling at a significant loss. I occasionally wondered what would have happened if I'd simply given in to Sharon's demands at the beginning. I could have shut down the kiln, taken a loss on my investment, and avoided all the conflict and trauma. But that would have meant surrendering my legal rights because someone with a petty grudge wielded bureaucratic power. It would have meant accepting that might makes right, that the person willing to be most unreasonable wins by default. More importantly, it would have set a precedent that the HOA could override state and county authority whenever it felt like it. Other property owners in Riverside Estates might have legitimate interests in agricultural activities, home businesses, or other pursuits that the covenants explicitly allowed. If I'd backed down, the next person might not have had the resources or determination to fight back. The rebuilt barn became something of a showcase. I started offering tours to woodworking classes and craftsmanship students from local colleges. The kiln operation was fascinating from a technical standpoint, and I enjoyed sharing knowledge about the wood drying process. Understanding how lumber goes from green, freshly cut wood to stable, usable material helped craftsmen better appreciate their medium. I expanded the business gradually, adding a small retail component where I sold dried wood directly to local woodworkers and hobbyists. I kept prices reasonable and focused on quality. The certifications and permits I'd fought so hard to defend now served as excellent marketing tools. Customers knew they were buying properly processed, professionally dried wood. 3 years after the fire, I was invited to speak at a national HOA reform conference in Kansas City. Property rights advocates, legal scholars, and frustrated homeowners gathered to discuss strategies for reforming HOA governance and protecting individual rights. I shared my story, emphasizing both the importance of standing up for legal rights and the need for reasonable community governance. HOAs serve important purposes, I told the audience. They maintain common areas, enforce reasonable standards, and help preserve property values. But they're not sovereign nations. They exist within a framework of state and local law, and their authority has limits. When HOA leadership forgets those limits, property owners need to be prepared to defend their rights, and courts need to be willing to enforce those limits. The speech was well received. Afterward, I spoke with dozens of people dealing with their own HOA disputes. Some were fighting over solar panels, others over disability accommodations, still others over home businesses similar to mine. I offered what advice I could and connected people with legal resources. Bob Hendricks served 3 years as HOA president before stepping down, satisfied that he'd reformed the governance structure sufficiently. His successor, a retired engineer named David Mills, continued the transparent, reasonable approach Bob had established. Riverside Estates became known in Springfield as one of the better-run HOA communities, a place where rules were enforced fairly and property rights were respected. I never did see Sharon after her sentencing hearing. I heard through various sources that she was housed at the Chillicothe Correctional Center in northern Missouri. Whether she ever came to terms with what she'd done or simply blamed everyone else for her situation, I don't know. I made peace with what happened, recognizing that some people are so invested in control and power that they'll destroy themselves rather than accept reasonable limits. The kiln hummed away in my barn, day after day, doing the work it was designed to do. I filled orders, served customers, and enjoyed the satisfaction of running a legitimate, successful business. The whole nightmare with Sharon seemed distant now, a bizarre chapter that had ended as justly as could be expected given the circumstances. One afternoon in late spring, I was stacking freshly dried red oak when a car I didn't recognize pulled into my driveway. A young woman in professional attire got out, looking around with interest. "Can I help you?" I called out. "Are you Harrison Oakley?" she asked. "That's me." She walked over, extending her hand. "I'm Jennifer Thornton. I'm a reporter with Missouri Life magazine. We're doing a feature on small businesses that have overcome adversity to thrive. Your story with the HOA and the arson came up in our research. Would you be willing to be interviewed?" I hesitated. Part of me wanted to leave the whole mess in the past, but another part recognized that sharing the story might help others facing similar situations. "Sure," I said. "Let's talk." The magazine feature ran 2 months later. It was fair, comprehensive, and focused more on the business itself and the lumber drying process than on the sensational criminal aspects. They included beautiful photographs of the barn, the kiln in operation, and finished wood products made by local craftsmen using my materials. The feature generated another wave of business. Orders poured in from across Missouri and even neighboring states. I hired 2 more employees and invested in additional equipment. What had started as a modest small-scale operation had grown into a genuinely thriving enterprise. 5 years after Sharon's arrest, she became eligible for parole. I received notification that I could submit a statement to the parole board if I wished. I thought about it carefully before deciding to write a brief letter. "Sharon Pembrook committed a serious crime against me," I wrote. "She destroyed property, threatened my safety, and violated the trust of an entire community. However, she has served her time as determined by the legal system. I neither support nor oppose her parole. That decision should be based on her behavior in prison, her rehabilitation progress, and the professional judgment of correctional authorities. My focus is on my business, my community, and moving forward productively." I don't know if my letter influenced the parole board's decision. She was denied parole that first time but granted parole 2 years later after serving 7 years total. By then, enough time had passed that I'd moved on emotionally. I heard she moved to Kansas City and worked in retail management. We never crossed paths again. The reforms that followed the case continued to benefit property owners throughout Missouri. The new laws prevented numerous HOA disputes from escalating the way mine had. Property owners with legitimate, permitted activities were protected from arbitrary HOA enforcement. The balance between community governance and individual rights improved significantly. Riverside Estates itself continued to flourish. Property values increased steadily, not despite the criminal case and the reforms, but arguably because of them. Prospective buyers appreciated knowing they were moving into a community with fair, reasonable governance rather than potential for abuse. The neighborhood developed a reputation, as a desirable place to live precisely because property rights were respected. I eventually expanded beyond just lumber drying. I started teaching workshops on woodworking, wood selection, and understanding lumber quality. Local craftsmen appreciated learning directly from someone who worked with wood daily. I partnered with several furniture makers to offer complete design to finish services, where clients could see their projects through from selecting standing timber to finished pieces. The business success allowed me to give back to the community. I donated materials for a community woodworking program at the Springfield Boys and Girls Club. I sponsored scholarships for students studying forestry and wood science at Missouri State University. I became an advocate for sustainable forestry practices, working with landowners throughout the region to promote responsible timber management. Looking back on the entire experience, from Sharon's first confrontation to where I stood now, I recognized how easily things could have gone differently. If I'd given in to her initial demands, if I hadn't done thorough research before buying the property, if I hadn't found a good attorney, if the security cameras hadn't captured clear footage of the arson, any number of factors could have changed the outcome. But I also recognized that standing up for what was right, defending legitimate legal interests, and refusing to be bullied by someone abusing authority had mattered. It had mattered for me, for my business, for the Riverside Estates community, and ultimately for property owners throughout Missouri who benefited from the legal reforms that followed. The kiln continued its steady work, transforming green wood into stable lumber, day after day, year after year. It was a simple process, really, applying heat and controlling moisture content, but it represented something larger. It represented the value of patience, of following proper procedures, of respecting both the material and the process. In that sense, it wasn't so different from what I'd learned through the whole HOA ordeal. You follow the rules, you do things properly. You respect legitimate authority while defending your rights when necessary, and eventually, things work out. The process might take time, it might be uncomfortable, it might even be dangerous, but if you stay committed to doing things right, justice generally prevails. I stood in my barn one evening as the sun set over the Missouri landscape, watching the kiln's control panel display steady temperature and humidity readings. Everything was operating exactly as it should. The wood inside was drying properly, becoming stable and valuable, ready for craftsmen to transform into beautiful furniture, cabinetry, and art. Outside, Riverside Estates was peaceful. Neighbors walked their dogs, kids rode bicycles, someone a few streets over was grilling dinner. It was just an ordinary evening in a residential community where people lived their lives, pursued their interests, and coexisted reasonably. That was all I'd ever wanted. The right to live my life, run my business, and exist peacefully in my community. It shouldn't have required a legal battle, criminal prosecution, and statewide reforms to secure that right. But sometimes, unfortunately, defending the basic right to pursue legitimate activities requires standing up to unreasonable people who abuse what limited authority they have. I'd stood up. I'd defended my rights, and ultimately, despite the trauma and cost, the system had worked. Sharon was held accountable. The community reformed its governance. Other property owners gained legal protections, and my business thrived. The commercial kiln hummed quietly in the background, certified and permitted, operating legally and efficiently, doing exactly what it was designed to do, just as it always had, just as it always would, and that was enough.